Okay, you have 2 minutes.
Okay, well, Nicholas Panos, I disagree with Patrick and John's sentiments. I've written a number of letters. I've written 2 complaints. I have a lot more information than they have. And I appreciate you deliberating over my complaint. I will reframe it to make specific accusations. I will also submit informational requests. But I need to tell you that there's a lot more that I have available to me. One of my colleagues, former colleagues, actually sued on the exact grounds that I have referenced in my letters. Pia knows this, the association's attorney, and it's under the Virginia Code. And she specifically won on grounds of the unauthorized use of funds. So I have all of her paperwork. She gave me everything, the legal complaints, the appeal, all the legal citations, the case. So my purpose in speaking is really to establish a record that I think the board is being grossly negligent. It's ignoring an obvious outcome that is going to be very costly to all the members when you have to start paying out claims. So I am going to sue. It's just a matter of when. I put in the complaint that was going to sue as of a date certain. That still may happen. I just want the insurance company to get all my information first and make a decision so they don't protect you, because I want you to have personal liability for what you're doing. Frank and I are very confident we will win in Virginia court. We have the blueprint now to make a cost-free claim. All I have to do is adapt the complaint to our facts. So I needed you to be aware of that, because if you continue to proceed and spend our money on condo property, then you are willfully doing so in the wake of a Virginia appellate court decision that P&Os exists. So that means that you cannot rely on counsel that your actions are lawful anymore. That's it.
Mr. Panos, can I just ask you a question? How are you so sure that it's what is condo property and what is not condo property? We've been asking you and Frank to provide us with that proof for months now, and you haven't, which is why we've hired lawyers and title searchers at great expense to the HOA to answer those questions. So I'm a little mystified as to how it is that, you know, if you have this information beyond the shadow of a doubt, I mean, please do us a favor and provide it to us.
Oh, I've been down to the city. I've met with all types of city representatives. I have all the information I need about ownership and what constitutes a common area. So the association has to own the property. That's right in the Virginia Code and our declaration specifically. I know that. So the HOA, our HOA, the master HOA, as some have alluded, has to be the owner of the property.
Yes, but it's not clear who is the owner of the property. That's the problem.
Oh.
So anyway.
So you're saying that for all the condo owners on the phone that I can just come and park in your driveway?
He's past his 2 minutes. There were the people on the call. Thank you.
Right?
Okay.
Are you saying that's a common area? I mean, Clea, come on, be realistic. Well, Sue, and you can make that argument that the HOA owns the condominium property. You're welcome to do that as a defense. You will lose and waste more of the association money, which, by the way, I think you're diverting from capital reserves, because the legal budget was much smaller than the amount that you have paid Clea, the amount you paid Pia. And I believe that you're doing these cost overruns in years in succession, and that further exposes the HOA to liability for me and other owners once they figure out what's happening. We haven't budgeted for over $100,000 in legal fees from last year or this year if we start to sue.
Okay, thank you.
It's a serious matter.
Your time is up.
Serious matter.